All right.
Honors.
You're up, Mr. Calco.
Yes, Your Honor. William Matthew Calco on behalf of the appellant, Mr. King. I'm glad we got that set, Judge Northcutt. We were having difficulty there.
I'm sorry, I did not realize that was happening. I can't hear what you're hearing from me.
Judges, may it please the court. Judges, this is an appeal on 4 separate issues. This is a supplemental petition to modify a parenting plan out of Polk County. We believe that there is a distinction that needs to be made as to what actually is on appeal, because it's our contention, Your Honors, that this issue was confused by the trial court and potentially by the appellee. When there's a modification, it's well-established law under Chapter 61.13 and governed by Wade v. Hirschman from the Florida Supreme Court, that there has to be a substantial material and unanticipated change in circumstances prior to a trial court being permitted to modify a parenting plan. That's the first prong. And then the second prong is getting into the 61.13 subsection 3 factors and what's in the best interest of the child. This appeal is merely about the first prong of this case. Wade versus Hirschman made it clear, and Judge Atkinson, Your Honor, concurred in a case for Hollis versus Hollis that reestablished the fact that a trial court is not permitted to go into a 61.13 analysis without a finding of a substantial change in circumstance. In this case, Your Honors, there was an agreed upon parenting plan by the father, Mr. King, and the mother, Miss Lewis. Subsequent to a final judgment being entered on that parenting plan, the agreed upon parenting plan, in the late 2017, early 2018 time period, Miss King suffered some mental health issues. Those mental health issues in January of 2018 resulted in her being involuntarily committed for mental health treatment. At such time, Mr. King filed an ex parte emergency pickup order that was granted by the court based upon a finding of substantial.
But let's say we assume for the sake of argument that the court had considered what you can assert it was a change in circumstances that's in the record based on those previous filings. Does every substantial change require the trial court to modify and require us to reverse if there was no modification? Or
no, Your Honor, but that would get into a best interest analysis. Once there's been a substantial change.
So wait a minute, you're saying that once there is a substantial change, there's a fulcrum point, and I think I see what you're saying. There's a fulcrum point and you're shunted into a best interest of the child. So you're saying that there was a substantial change and there was not a best interest of the child analysis done?
What I'm saying is based on the final judgment, which appears in the record at pages 284 to 286, the court never did the best interest analysis. So what I'm saying is I like your fulcrum point analysis where it says once you have a substantial change, you then enter into a best interest analysis. I'm certainly not saying because there is a substantial change that the court must modify the parenting.
But I don't read your arguments as saying that the error was a failure to undertake a best interest analysis. Was that your argument?
Essentially, I think the argument focuses on the first prong. I think your question focuses on the second prong.
So how does the second prong, because you're talking about the best interest, how does that inform whether we ought to reverse the decision, which you said was based solely on what we're now calling the first prong, which is whether there was a substantial change?
Correct. What I'm saying is the substantial change had already been met. Therefore, the court's error was twofold. One, in finding that there was not a substantial change in circumstances. That's the initial error. And because the court found that there was not a substantial.
Okay, let's focus on that error. So you talk a lot about permanency and the fact that you believe that was grafted onto the standard and improperly by the court. But these words like substantial, they have a lot to do with the factual circumstances. And couldn't it be that the fact that to the trial court's understanding it wasn't permanent could inform whether it's substantial? In other words, whether there was a change that may have even at one time been substantial, and then the alleviation of that change made it insubstantial because he or she thought, well, this is not permanent. It's being addressed. And
I see that argument. My position on that, Your Honor, is that gets into the best interest analysis. And I think that looking at the final judgment itself moots Your Honor's position in that respectfully. And here's why.
Just let me pause for a second. That's where I'm confused. I thought I was talking about the word substantial, which is an analysis that has to do with the change in circumstances. And then you're saying that I've hit the fulcrum point, and now I'm talking about the best interest of the child. I didn't think I was.
See, that's where I think that you are, Your Honor. And the reason being is if you look at the Perez versus Fay case, which is the second DCA case from 2015, the factual circumstances in that case are identical. I cannot find the only factor between Perez versus Fay and King versus Lewis, the case before Your Honor, is procedurally how it got to the Second District Court of Appeals. Our position ultimately is that the change in the circumstances was the arising of the mental health condition. Your Honor, is that in paragraph 6 of the final judgment, it says that the mother, she continues to attend voluntary sessions, and they being the mental health professionals, have no concern regarding the mental health nor ability to parent going forward. The final judgment does not find, and the court does not find that the mental health condition no longer exists. And by analogy, what I would say is, let's say a parent develops a cocaine addiction after a final judgment. That parent develops a cocaine addiction, lives in cocaine addiction, a pickup order is entered, parent enters treatment with a supplemental petition to modify in place. The parent with the addiction goes into rehab. The addiction still exists. The addiction at the final judgment still exists. Now, the effect of the parent's ability to parent is not a substantial change issue, in my opinion. I'm proposing that whether or not the parent has the continued ability to parent is the best interest.
So you're saying that if the effects of the change have nothing to do with whether it's substantial?
No, what I'm saying is the fact that the mother still had the mental health condition at the time of the hearing, the final judgment does not find, and the court does not find, that the mother does not have a mental health condition at time of trial. What the court,
the court concluded that it was not substantial or material.
And
But
that's
that word material, I think, is significant as well.
And that's where I think that that's part of where the error is, because that's just the opposite of what Perez v. Fay found. Perez v. Fay, in an identical set of circumstances, I cannot differentiate the actual facts of that case to this case. As an appellate attorney, I couldn't have written an opinion with a closer set of facts. And that's where I believe the trial court erred, because Perez v. Fay permitted to move into a best interest analysis. And that's where this court overturned the Perez v. Fay trial court.
Well, you probably need to address, because your opposing counsel is going to address it, the distinction in the procedural posture of Perez. There was that's a pertinent distinction.
Correct, Your Honor. And that is the only distinction that I can find, is how procedurally it got up to it. The concern that I pose to the court is if this court upholds this ruling on this set of facts, on the identical set of facts, both the procedural mechanism of how it got to the Second District Court of Appeals, the trial courts don't have guidance as to whether a new mental health condition is a substantial change. Perez v. Fay will say the arising of a mental health condition is a substantial change, and then King versus Lewis will say it doesn't necessarily mean that. It means ultimately, procedurally, depending on how it gets to Second District Court of Appeals. Because when you look at the Perez v. Fay case, the trial court hinged its opinion, and I apologize, Judge Northcutt, if I could have 5 minutes remaining. I meant to ask that up front.
No problem.
Thank you. If you look at the finding in paragraph 6 of the final judgment says she continues the treatment and there's no concerns. In the Perez v. Fay case, it had the exact same finding. On page 463 of the Perez v. Fay case, it says, however, she, the mother in that case, produced uncontradicted evidence that there was no further incidents. Her treating psychologists testified that the mother was following her recommended treatment protocol. That's the exact same finding in this case. So the concern that I have, and the concern I think the District Court of Appeals should address, and why I think that this is an error, is because if the court says the only distinction difference is how procedurally it got before the District Court of Appeals, it doesn't give guidance to the 12th District Circuit, the trial courts, as to whether or not the District Court of Appeals believes an involuntary commitment of a mental health condition from a parent ultimately will lead to a substantial change.
But doesn't that depend on the mental health condition? I mean, you can't just say a parent has a mental health condition unless you want us to hold as a matter of law that a mental health condition constitutes a substantial material change, period. Which sounds like what you're asking us to hold.
I'm not asking your honors to hold that broad of a ruling. What I'm asking is to hold that when a parent is deemed to be involuntarily committed based upon a mental health condition that didn't previously exist, that's an analysis that a trial court should determine on a best interest analysis. And I believe that's what Perez v. Fay already did. Perez v. Fay had already found that there was a substantial change in circumstances.
But let's imagine a scenario in which someone was involuntarily committed, and we can all agree that was a change. And then at hearing, evidence was adduced that the treatment had completely resolved the situation, and it had no more effect on her life, whatever it was ailing her at the time of involuntary commitment. Would the trial court abuse discretion by saying that that was neither substantial nor material a change at the time of the hearing?
Based on Perez v. Fay, I would say yes, Your Honor, because that's ultimately what the trial in court in Perez versus Fay found. Perez versus Fay specifically found that the treating psychologist testified that she was following the treatment protocol, and effectively they were making recommendations that go into additional time sharing. So I'm not saying that I'm asking the court to make that finding. I'm asking the court to reaffirm the finding in Perez versus Fay. I think the court has already taken that step. And again, I'd like to reiterate, this is not an issue necessarily that guarantees and requires a modification. What I'm saying is it gets us into a best interest analysis, the way Perez versus Fay did. And I'm not saying that ultimately the mother in the Perez case or this case rectifying that situation. I believe, and I propose that had this gone and had the court determined that it would be in the best interest of the child to go back to mom, this appeal would not be happening, because that is a best interest analysis. I think the Honor's looking at it as to the effect on the child, which I don't believe is a substantial change analysis. I believe the effect on the child is the best interest. I'm simply saying,
walk us through what the trial court should have been thinking about with regard to whether it was substantial or material. If it wasn't some effect on the child.
I believe that the substantial change was the arising and the existence of the mental health condition. So the court should have gone into a.
Well, what if she got a new job? That's a change. And isn't the trial court supposed to determine whether it was substantial or material based on the topic at hand, which is parental, custody? The child.
I would generally agree with that. I would generally agree with that statement, but we're dealing with mental health here. I could go back to my analogy with regard to the cocaine abusing parent. The fact is the mental health condition still exists. In our situation, that is the substantial change. A parent who develops a drug addiction, that is a substantial change. Now, once you get past that crux point and into beyond the substantial change, it's our position that the trial court could then say, mother has rectified the drug addiction or has rectified the mental health condition. Therefore, it's in the best interest of the child not to modify the parenting plan. That's an analysis that had the court made that determination, the appeal would not be occurring. But based on the Perez versus Fay case, I'm of the opinion, and I believe that this court has already drawn that line in the sand, where a parent who is involuntarily committed, that leads into a best interest analysis. because the Perez v. Fay case is ultimately identical in circumstances beyond the procedural mechanism of how this court heard Perez versus Fay. For the permanency issue, first, I think that the appellee is breathing in their answer brief. There's no case that references that I could find that the permanency required. And even if your honors believe the permanency be required, even if that's true, the permanency has existed. The mother has the mental health condition.
Do you read the, let's we can assume, well, I don't want to assume that because I don't read it necessarily the order as requiring permanency. I think the question is whether permanency is just not as a term of art, but as just a word in ordinary meaning. The word is relevant to substantiality and materiality. Let's say mom went out and snorted some cocaine at the club, and that was an isolated incident. Isn't the fact that her drug use was impermanent, doesn't that relate to whether the change is substantial or material?
I would absolutely agree with that. And I would agree with that because that's an isolated incident. What we have here is an ongoing incident. I think the better analysis is the development of the addiction. The use of a singular drug, I don't believe would necessarily be a substantial change, a material change. What I'm saying is at the time of trial, there was a mental health condition that existed with the mother. It was being treated, but it existed. There's no finding by the trial court and nothing in the record to indicate that it didn't exist. In fact, I'd argue paragraph 6 of the supplemental final judgment concedes that it still existed as the mother was still seeking treatment for it. The mere fact that there was no current concerns or future concerns, that to me is of best interest. The mental health condition existed at the time of trial. There's no question in the judgment that still existed. That goes back to the difference between using cocaine one time on the weekend versus developing what is a diagnosis of an actual addiction. An actual addiction is a different story because an addict is an addict for life. Whether they're an active addict.
At your 5-minute mark.
Thank you. So we would be asking the court, and I apologize, Judge Northcutt, your audio is off again. It's a little muddy, at least to me.
Well, I'll step into Judge Northcutt's shoes momentarily. Would you like to reserve the rest of your time?
Yes, Your Honor, please.
May it please the court. Can you hear me okay? My name is Jean Henney and I represent the mother in this appeal. This is an appeal from an order denying a petition for modification. The standard of appellate review is an abuse of discretion standard. So in order to reverse, this court must find that the trial court's ruling was arbitrary, fanciful, unreasonable, or that the factual findings weren't supported by competent substantial evidence. The problem for the father, the biggest problem for the father in this case, is that there's no transcript or suitable substitute. Therefore, it is impossible for this court to reverse finding an abuse of discretion or a lack of substantial competent evidence.
I actually, you spoke about something I was about to ask you about, if you don't mind me interrupting. Let's say I think we've sussed out appellant's position. I understand. I use the term fulcrum point, but and I think you might have agreed. Let's say we assume his analysis to be correct legally on how a trial court should analyze substantial material change and when the trial court should shift to the discussion of the best needs of the child. In an absence of a transcript, assuming that we agree with the appellant's analysis, is it possible for us to find grounds for reversal based on the face of the record because the trial court didn't undertake the analysis in the way that the appellant says as a matter of law he should have or she should have?
Well, you're right. So the error would have to appear on the face of the judgment. And it's my understanding that the appellant's arguing that the addition of the term permanent in there created an error on the face of the judgment. there's several problems with that, is that it's not a quote. It's not a quote from the statute that's misquoted. It's not a quote from Wade versus Hirschman that's misquoted. In this case, there was a temporary modification of time sharing based on a mother's mental health issue and then a domestic violence issue. So we come to the final hearing and the judge is analyzing whether there was a substantial material change of circumstances. We already knew there was a temporary one. Now the judge is saying, well, even though there was a temporary one, based on the evidence that I have presented in front of me at this final hearing, I'm finding that it doesn't meet the extraordinary burden to show a sufficiently substantial and sufficiently material change.
In other words, can you hear me? I'm sorry.
Yes.
Can you hear
Yeah,
me? Okay.
perfect.
In other words, what was a substantial and material issue for purposes of a temporary suspension of the parenting plan is no longer material to the parenting plan.
To overcome the res judicata effect to the finality of the previous.
Correct. And isn't that, in reviewing that, we're reviewing that for an abuse of discretion, just like what happened in Perez, only we're determining whether it was an abuse of discretion to deny the modification, whereas in Perez, we were looking to determine whether it was an abuse of discretion to grant the modification.
Well, in Perez, this court upheld the trial court.
Yes, we upheld the change, the modification of the parenting time from majority mom to majority dad. And we found no abuse of discretion. That's what we're looking for. And that's a case-by-case inquiry, is it not?
Certainly, yes. That's a case-by-case inquiry, but in Perez, this court could look at the transcript, and it's a transcript. It said the evidence presented at trial. And the interesting, Perez isn't actually on all fours because the parenting evaluators recommended that the mother should transition from supervised time sharing over a 6-month period of time. So we come to the final hearing in Perez 2 years after the original incident, and the mother still had supervised time sharing. So the mother in Perez was getting better and doing what she was supposed to. In the instant case, the trial court found, and we must assume it's based on competent and substantial evidence, that the mental health professionals all said, not only has she complied, she's completed because we have no concerns about her ability to move forward. And the fact that she's attending voluntary sessions is not evidence that she continues to suffer from a mental health issue. She's getting, so she's a single mom, she's getting support. A lot of people attend voluntary support sessions. So that would not be an error on the face of the judgment by any standard that this court would have previously used. And that's basically the argument. There's no error appearing on the face of the judgment. The use of the could have described lots of things. It was not a legal error. Therefore, this court must affirm.
Thank you, Ms. Henning. Okay, Mr. Calco.
Thank you, judges. Very briefly, because we didn't address the issue of the transcript, I agree that the final judgment comes to your honors with a presumption of correctness and it was founded by competent substantial evidence. That's not in dispute by the appellant. What we're disputing is that the record before your honors clearly shows that Perez v. Fay and the facts and circumstances in that case warrant at least a best interest analysis. And that's where we believe, and I believe, that the trial court erred and abused its discretion in this matter, was because the court had already found that the arising and the existence of a new mental health condition was sufficient for the purposes of a modification of Perez versus Fay. The fact that the mother still had a mental health condition was seeking voluntary services for that. Again, the court doesn't find, and I don't believe the court can breathe in, even with the lack of a transcript, that the mother no longer had a mental health condition. That's not a finding of the trial court. What the trial court found was she was complying with the treatment and there were no immediate concerns. I believe that from a trial lawyer's perspective, bringing a substantial change in front of a court, a ruling that would affirm this trial court's supplemental final judgment could potentially create, it may very difficult for a trial court to determine what is the threshold when a parent goes into involuntary treatment and a new mental health condition arises. This is not a situation where mental health was in any way at issue in the original case, prior to the original final judgment. This is a situation where a mental health condition arises. Now, it doesn't necessarily mean that the parenting plan must be modified. Simply that a parenting plan can be modified. And I believe Perez versus Fay is controlling in this court's finding by permitting a substantial change, by permitting and upholding the substantial change in Perez, in permitting the best interest analysis. That's where this court abused its discretion by cutting it off and saying that Perez v. Fay, that the findings, they didn't address Perez versus Fay. So our position is that that issue holds, that the arising of the new mental health condition subsequent to the final judgment is in and of itself the substantial change that existed. Now, the effect on that is whether or not it is in the best interest. So our opinion, judges, is the court abused its discretion in failing to do a best interest analysis and follow Perez versus Fay. So we would be asking that your honors reverse the final judgment, order that there is a substantial change in circumstances, in order that there be a best interest analysis and a retrial on that issue. Thank you, your honors.
Okay, thank you both very much. The court will
Are we
be in
excused?
recess. Hello, can you hear me?
Are we excused, your honors?
I said thank you both very much. Court will be in
Thank you.
recess for 15 minutes.